Today, we will work with Siddharth on understanding how we can improve legal systems in India and his work around those areas. Welcome, Siddharth, to the show.
The first thing that I want to set out straight up is there is a fundamental lack of good data in the legal system. If you look at what Supreme Court's what judges have said, they keep saying we have very few judges. Now, this is one of those things which is true of India at all points. If we have weak state capacity at a level. So yes, we need more judges. That all our tropes about High Court, the Tariq pe Tariq.
What is a good model to follow?
Naturally, more judges should mean more disposals. Judges working harder, which is judges not working on holidays, should lead to better efficiency.
India works with a lower judge capacity of 20 per million, and we have on top of it multiple vacancies in various courts, right?
At least at the district court level, saying that adding more judges is perhaps not necessarily going to push it. What you need is greater state capacity. So recent blog, which is on summons, I think we need to study these systems better. We need more empirical data. We need more results. I don't think tribunals can function if the main judiciary does not do its work.
I'd like to welcome all our viewers to the latest episode of the Coffee House Experience. It's a pleasure for me to host my old IIM Ahmedabad batchmate Siddharth Raman for today's show. Unlike me, Siddharth went on to do super interesting things post-campus. His latest stint is as a researcher working at the XKDR Forum, which was co-founded by Ajay Shah and Susan Thomas in 2020. And today we will work with Siddharth on understanding how we can improve legal systems in India and his work around those areas. Welcome, Siddharth, to the show.
Thanks, Sanjay. Happy to be on this.
Yep. So maybe let's start building intuition for this at the very outset, right? We have on an average 34 million cases which are pending for over a year across India's courts. India's judicial structure is obviously the Supreme Court at the apex. There are 24 state-level high courts, 672 district courts, and 6,000 plus subordinate courts, right? So with India, we always mention that India has limited state capacity. Over here, what is the state capacity issue in your sense? Is it sheer numbers, low manpower, or is it that our judges aren't doing as much as they're supposed to do?
Okay. So let me first start off by, like you, I'm not a lawyer. Okay. So I come into this world from a background of engineering and management. And my first question, I entered this space about 3 years back, right, in 2023. And my first question was, okay, tell me, let's look at a case type. How long does it take? And I was both puzzled and fascinated that nobody had an empirical answer to questions of this nature. So the first thing that I want to set out straight up is there is a fundamental lack of good data in the legal system, both in terms of data collection that the courts do, also in terms of the amount of public data disseminated. But I also want to say in terms of the tools and the statistical methods to try and analyze the problem. The one data that we have, like you said, is that there is a lot of pendency, and a lot of the pendency is really old, right? Like greater than 1 year, but we don't really get, actually the National Judicial Data Grid, which keeps improving every year, now gives you a nice timeline of, okay, cases greater than 1 year, how old are they, right? Which is it gives you a sense of the aging. So I think at the very outset, the data is weak, it's getting better. So now let's come down to, yes, fundamentally, there is lack of capacity. If you look at the Reforms Commission, Law Reform Commission reports, if you look at what Supreme Court judges have said, they keep saying we have very few judges. Now, this is one of those things which is true of India at all points. If we have weak state capacity at a level. So, yes, we need more judges. But I would urge people, and this is not an easily solvable problem in the short term, perhaps in the long term. But why are we in such a position? And then you start looking at, okay, let's look at what happens in cases. Because without actually understanding the life cycle of a case, so pendency is a stock figure, right? You kind of know how things are at this moment. But unless you understand the flow of cases through the system, it's very hard to try and understand why it's breaking down. So we recently have a blog post on the Leap Journal where we look at two case types only. And this is in district court, because one of the things I understood when I came in, that all our tropes about High Court, the Tariq pe Tariq, and 100 matters, perhaps, sorry, for your audience, this is what happens in a day in court, okay? So court starts anytime 10 versus 10 or 11. That's to sit for anything 6 and 8 hours. There are a few matters which are listed on the docket, okay? It's called a cause list. And then judges go through the cause list. They go case by case. There is a funny roll call that happens, at least in district court, where first they take attendance, and that takes a long time because there are lots of cases. And then they hear some matters. And in High Court, it is very common that you will never close the cause list. There are just so many matters. So even if there are 50 to 100 matters, maybe the judge 12, 15, in a good day, 20. In district court, it's very different. In district court, at least for the cases that I've seen, and I've spent a fair bit of time now in district courts, the cost list ends. It's just that there's nothing that needs to happen in the matter, right? So most of them are adjournments. Either party isn't ready. Sometimes the judge isn't ready. Sometimes the stenographer isn't ready. And there have been cases where there have been days where I've seen adjournments happen because court staff not ready. So there are multiple reasons. In my opinion, after looking at these cases, it is that there is not enough drive in the system to push cases to get through the system faster. So there is nothing in the system in terms of incentives that motivates faster disposal necessarily. And the process is such that if there are delays, if there are requests, there is no penalty to anybody. So adjournments keep happening. They're very, very frequent. As much as from a quick dipstick that we've done, 70 to 80% of hearings are adjournments. And so nothing really moves in a case, which is why, yes, we need more judges. But I fear that our efficiency of process is almost invariant to pendency or number of judges, because the judge themselves do not have the tools or are afraid to use the tools to push the case towards faster disposal. I'd really recommend this book called Tariq Pe Justice, which is a new book focusing on district courts by Chitrakshi Jain and Prashant. And they kind of highlight what are the bottlenecks at the level of the district court, and we don't understand this enough. So I want to be very clear. High Court, very different. District Court, very different. Intellectuals focus on High Court and Supreme. I really think a lot of focus is required at the district court level as well.
A couple of statistics which I actually have picked up from Karthik Mulyadharan's book. In the UK, the recommended judge strength is 51 per million. In the US, it's 107 per million. India works with a lower judge capacity of 20 per million, and we have on top of it multiple vacancies in various courts, right? So there's obviously a manpower issue there. The second thing that often gets bandied about, at least in popular media, is about our Supreme Court in specific enjoying more vacations, right? They often get hammered for having long summer and winter breaks. And although there is a vacation break, the rate of disposal of cases is much lower there. In the US, it's a different setup where they don't have these predefined breaks. You can take breaks as and when you like. And even when you're on a break, you ensure that the roster is strong enough to let cases get processed on the fly. There is no period where the court effectively stops working in some sense. How effective are vacations in explaining away some of these delays in processing cases, explaining pendency in general?
Yeah. So my colleagues have done one blog on this, which is what is the impact of vacation days. And they noticed that, look, obviously, on the dates of the vacation, the number of filings and disposals drop. That is to be expected. There is a lower bench strength. But for the cases that are filed in that period, there is really no difference between if the case was filed before vacation or after vacation, which means statistically it makes no difference. So think of it this way, that everybody thinks that the flow of cases through the legal system is like, it's very smooth. So you add a bigger pipe, more cases go through it. But the flow of the water depends on the pressure on both ends, in fluids. And in this case, you have to ask what is actually pushing the case through the system. So even if I start the case early, the flow of how many hearings happen, when do those hearings happen? What is the gap between the hearings? How many of those hearings are adjournments? Unless you actually get down to understanding that at a minuscule level, we are left with some of these like, of course, why can't our judges work on holidays? Sure, they could. And, perhaps they should. I don't know. But will that really move the needle? It is like, okay, instead of one developer, you put 10 developers. Sure, you can get a lot of low-level code written quickly. But at High Court and Supreme Court levels, where you need a lot of thinking, is that where the problem is? Is that if we made our judges work just 10% or 12% harder, is that going to move the needle? And I don't want to stick my neck out and say yes or no. Maybe we should experiment. Maybe 1 year we give them a holiday, 1 year we don't. We see what happens. But I would argue that at our most fundamental level, we must push for more quantifiable evidence. We need, I often joke that we don't get a lot of data from the legal system because maybe the smart people of India who didn't like math are the ones who decided to go into law. But we must push ourselves to say, look, the rest of us now understand operations. The rest of us understand things like there are bottlenecks. So if you have a 10-lane highway, but it converges to 1 lane at that point, at the intersection, adding more lanes upfront is not going to make a difference. Another Professor Nitin Bakshi has a paper looking at the Supreme Court. There are two, he breaks it up into 2 buckets where he says, look, the cases that get admitted, okay, that's a big question of should this case even be heard by the Supreme Court? And there is a funnel there. And then there is a funnel of, okay, now let's look at these cases. So do we have capacity at all levels, at admitting the case, at managing the case, at scheduling? And one of the things is, I feel like this, it's very easy to get into at a very high level. It's easy to say, naturally, more judges should mean more disposals. Judges working harder, which is judges not working on holidays, should lead to better efficiency. And maybe there is a corresponding drop in quality. Maybe the judges are spending their time in these vacations thinking about constitutional matters or how to solve cases or preparing for them. I don't know. We must get our judges to speak out more and understand how much effort goes into writing a judgment. So I would urge everybody to say, yes, you can have your intuitions, and maybe those intuitions are correct. But can we demand more empirical, more rigorous work to establish these things? I am at this opinion, at least at the district court level, saying that adding more judges is perhaps not necessarily going to push it. What you need is, you need greater state capacity. So recent blog, which is on summons, which is so the court is actually 2 processes. Okay. And we don't talk about this enough. There is a judicial aspect to the legal system, and this is our mental model of my lord, right? There's a lawyer who's standing in front of a judge, and arguments are being raised, evidence, citations, deep legal conversations, interpretations. This is what our Supreme Court video hearings would have us believe, because those are interesting, and now there's a live broadcast, and it's fascinating. But go to the district court, you don't see such matters. And behind the very interesting front end of argument, large administrative system, which is ensuring that files are being maintained, information is being tracked, things are being filed properly, scheduling dates are given. people need to alter these scheduling dates, right? So if I give you a dentist appointment and I'm a dentist and 15 of you turn up and I only listen to 3 of you and say, okay, now come back 2 months later, that's not a functioning medical system. But for some reason in the judicial system, we've accepted that, somebody turns up, they say they're not ready. Okay, calendar, court is very busy. Let's give them the next empty date, which is next month. And this has become acceptable, right? We don't hear enough clamor, and there's not enough pushing to say, okay, why did you give an adjournment? Can we penalize the party who was not ready? Can we impose costs? What in the system is driving it to efficiency? I haven't understood the answer to that question, except that there are some really good judges. I think we need to study these systems better. We need more empirical data. We need more results. And the US has a lot of this. So they passed something called the Civil Justice Reform Act. And the Rand Corporation, many, many years later, did maybe some time later, did a nice study, because it was a natural experiment of some sorts. Some judges, some districts or states implemented those laws. Some did it partially, some did it later. And then they said, okay, what happened? E-courts program, a lot of money. They have now forced every district court file online. Now, online filing is a good thing. Okay, I support it. I think it's a great idea. But if you ask what happens to those filed cases, every district court lawyer will tell you that apart from some exception, Delhi has some really good judges, cases, court to do things digitally. Everything still happens by paper. So all you've done is you increase the burden of, file it online, file it on paper.
And the poor, basically, you don't replace A with B, basically.
You do both. Now. And the poor chap on the back end and the court staff, and, not enough gets talked about there to right? They now not only have to check that your legal filing is correct, they also need to ensure that there's a 1:1 correspondence. And what did we achieve? Have we done any studies? Did it move things? Did it make people's lives easier? So our intuitions on this are often not necessarily accurate. And we need more experiments. And we may not necessarily be able to look at the West for some of this, because like you said, our state capacity is so poor that all the other surrounding foundations of a good legal system, a good police that can get people to court on time, adequate police so that, when the criminal is in jail, waiting bail, you have a police escort to make them come to the court, or if they can't, set up video conferences. It is such a complex system, and there are so many moving parts. And I hesitate at saying this is the one problem. What I understood is that there are no incentives in place, or not enough incentives in place. And I have gone and observed district court, and it looks like it is easy to get a adjournment. That's what I can say with certainty. And so it's a complicated problem, and I don't think I know more than that.
Yep. So as I think for our viewers, I just want to mention that whenever you have a Tariq pe Tariq scenario, it imposes costs on both parties, right? Because you need to pay your advocate for the number of days they are appearing on your behalf in court, and it's time lost on your behalf. You could have done something better, watched a movie, just chilled at home, but you are there sitting at court waiting for a call. There's just a cursory perusal of your documents, and then there's an adjournment saying, come back more prepared, come back with A, B, C documents, and then we'll hear the case. So it's time wasted for everyone, right?
Yeah. I want to say that we have argued within XKDR Forum that today, if you ask judges, what are they striving for? Tell you, and I believe that they're all striving for correctness, which means the highest thing that you want to hold is there is no miscarriage of justice. You follow. If somebody says they're not prepared, then we should give them the time to prepare. And this seems fair, right? So correctness is at that high altitude. And then everybody is concerned about speed, and maybe there is a tussle between these two. But we argue that it's as important to have predictability. And I would, in fact, put predictability in this. So if I enter into a legal case, I want to have a broad estimate of how long it will take. Okay, I want to know how many hearings will happen. I would love to know what kind of lawyer I should get, because if I'm paying my lawyer per hearing, if it's 100 or whatever, 50 hearings versus 5 hearings, if my cost is the same, I can use a 10x lawyer in terms of cost. right?
Right.
Of how much I have to pay. So I want to know when will I have my hearing so I can plan my days, right? I don't want to suddenly be told come tomorrow. Or okay, it could be any time between 1 month from now and 6 months from now. So, live in constant anxiety. When I show up to court, I want to ensure I'm heard. Is that something that can be granted? Can we get good scheduling systems in place that, airlines have this problem, right? Some people don't turn up and you turn them away or it's cancelled. Sometimes you overbook and they figure this out. Trains have figured this out. So are we saying that why don't have a good enough scheduling mechanism, right? And once things are scheduled, can we ensure that both parties are prepared? If not, can we not waste the time of the court and the people involved? Like on a day where, 3 days before you have your hearing, you do a web check-in of sorts and say, look, yes, I'm ready. Yes, I'm ready. These are ideas that the rest of the world has implemented. Um, I am at a loss to understand why the legal system does not adopt some of these ideas, maybe not all of them. Like some of these ideas, I want to say, may not fit in a criminal context, right? Because it's justice. It's different. It is unique. It is specific.
Right.
There are other issues, liberty, etc., to consider. But in civil matters, can we try some of these ideas out? We should be able to. I know there are some judges in Bombay High Court that are trying to say, okay, I will give you 20 minutes to argue. So I can plan the day. I can ensure that if I have 10 arguments of 20 minutes, it shouldn't be that the judge doesn't know what their day looks like. So they just block up 30 cases in the hope that they will get to them. I there are basic operational efficiencies that can be achieved, which could be tried. And
Right.
I know there are some courts in this country which are. We should do more of that.
Yep. I'll ask you one meta question before we double click on the nitty gritties of what you just proposed, right? What is a good model to follow? Do you want more expansive case law and ensure that justice is delivered in a more efficacious manner, or do you want to go down the route of having multiple special entities, bodies adjudicating cases? So, for example, I think one of the I think the pet projects of Dr. Ajay Shah was having this SAT and other tribunals combined into something. To combine into an FSAT of sorts, right? And maybe have more special NIA courts and so on and so forth. Do you think that is a sustainable solution, or is that just band-aid? You just are addressing the problem in a knee-jerk fashion, but you're not solving the root cause in some sense.
Yeah. So I would argue that while there are some instances, so ideally, I agree that regulators need appellate tribunals because otherwise where do you go, right? And you need some amount of specialization. Some of these securities transactions are really hard to understand. You need deep expertise in securities law and you need to understand how markets work. And I would argue perhaps it's true for GST and income tax. But I don't think tribunals can function if the main judiciary does not do its work. Because let us say you want to argue against the tribunal. Eventually, it goes back into the court system. And the people who end up occupying the positions on these tribunals are former judges. So without having a broad, high-level capability at the general judiciary level, I think you can set up these tribunals, but they will not be as effective as you wish them to be. And more importantly, if people wish to protest those tribunals appeal against the decision of the tribunals, anyway, the matter goes back. So what you need is you want really strong case law. You want a really strong precedent. You want strong adherence to precedents so that people won't appeal. See, today what happens is again, I don't want to talk too much about it because I'm not a lawyer. I also have tried to think about this problem and I'm not very sure there are very good measures of what a good judgment is. A good judgment is only a good judgment by its own, only judges can decide what a good judgment is. It is kind of self-referential, right?
Yep.
And but can we all agree that if there were consistent judgments and good precedent, first, a lot of cases will simply not come to court because we know that this is established law. Now, if there is not high levels of adherence to this precedence and predictability and certainty, then I'm tempted to appeal. Who knows? you could always get an overturn. You need strong case law, you need judiciary. And once you do that, you can set up specialization, because let's all agree that some matters require some levels of functional specialization. But you cannot do this at the cost of, you have to do this. Without this, the second will not work. So one is necessary, but it is not, it is not sufficient.
Got it. Got it. So now let's get back to what we were discussing just before this point, which is looking at the administrative machinery that runs behind the scenes in any district court, right? So I think a desiderata of sorts would involve a more efficient scheduling of cases. So judges have to maybe do context switching less, more asynchronous communication, where you don't need to actually go to the court on the day to find out that your case will not be heard. It's deterministic. You know that this is the amount of time that a hearing would likely take. There could be a mock hearing of sorts. You know what the day looks like, and you are pretty sure how about when you need to reach the court and how long you need to be there. So what are your thoughts on what some of the good administrative reforms could be to enhance the efficiency of the legal system?
Yeah. So one, I think we need a proper scheduling. We need an approach to scheduling that is not queue driven. It is slot driven. Okay. Today, all of us book calendar meetings, and, everybody broadly has understood this coordination system. And we all understand that some meetings extend and some meetings don't, but we manage through our lives. Right. So one, you need scheduling. Second, if people should agree to turn up, and if they agree, they should. And if they don't, there should be costs. They should. Now, I know that there are arguments against costs. It's unfair to poor people. It's unfair to the system. And it's all true. We need to find ways around this. Maybe the party which loses pays the costs. I don't know. There are ideas. We should try them out. I would strongly urge you and your listeners to check out this project that the Kerala High Court is spearheading, called On Courts Kollam 24/7. XKDR Forum is part of a larger collective called Pukar, who's acting as knowledge partners. And in some of this, through the On Courts project, the Kerala High Court is actually setting up systems. So you can't do scheduling if you don't get good data. So if I don't know what happened, if I don't know the long history of what all has happened, then I don't know how many hearings I can slot into my day, how long hearings should take. And On Courts project is a great attempt at collecting good data, because then you can feed it into the system. You know that, let's say it's the first hearing of a case. Broadly, itna time lagta hai. Then, evidence witness has to come. You have to introduce. Maybe it takes 20 minutes. So you can build a nice model that says, and it doesn't need to be a complicated AI machine learning. No, you have bin packing algorithms, which are very, very old. And, we can start with basic math and basic stats that, has tried out very well across other domains, and introduce it. Let's see what. So every court should be judged the same way a judge is judged, okay, on their disposal overturn rate. So if the judges make too many bad decisions and they get overturned, the High Court takes notice. And it's not known to us, but there is something called the annual confidential report that tracks some of this. Court staff can be judged on their scheduling efficiency. How many hearings did you have to turn people away? How many hearings were you within 5 minutes and within 10 minutes? And use some algorithms, but take some responsibility. Somebody should be held accountable for this. And I fear that this sense of predictability is important, accountability is important, urgency of getting things running right. And maybe it is because justice has always been so precious that we fear that efficiency and some of these ideas could corrupt the practice of justice. And we should be careful. We should give as much discretion. None of this should be constraints on people or on the judges, but can we push towards a slightly more predictable system?
Now let's go to the consumer facing aspect of this, right? So if I am a layperson and I want to really understand what's the actual impact of any proposed process re-engineering reform or something to that effect, what are the kind of core statistics that one could look at? Then maybe if you could build the intuition without getting into the formulae of the kind of core statistics that could be useful here, and which body should ideally publish these statistics, ideally, if we had some sort of centralized statistics organization, or even better, a state level statistics organization who could depoliticize this data and publish this regularly, then that would be awesome. Unfortunately, we don't have something similar in India now. So how do you envisage this sort of interface?
Yeah. So let me tell you, there is a report on this. Okay, I forget the name of the report. I will look it up and tell you all. But it was justice. Somebody had done a data standards report. Okay, and it's a good report. We should all try and aspire to it. There are, I'll reference it towards the end. Okay, I'll find it and tell it to you. But there are a few things that we have been looking at which take the side of the litigant, okay, which say from the litigant's perspective, what do I care about? Do I care about the pendency? Do I really need to know how many cases are pending? No, I'm a consumer of this service. I want to know how long will my case take? It's a reasonable ask. I want to know how many hearings so that I can plan my costs around it. I would love to know predictability. Okay. I would like to know now. It is unfair of me to demand outcome predictability. Okay, because a case will go to court. It's an adversarial system, which means both parties will present their facts. The law will take its course. I'm not here to suggest that you will know whether you will win or lose. That's not realistic. But can I at least know when my hearings will be held? Can I get certainty that the case will progress through the hearings? So, and then can I also get some kind of predictable pattern? So, American Supreme Court example, perhaps not the best parallel, but here it is, that when the trial of Trump was happening, okay, and the world was watching because the president might get, sent to prison or not, you knew dates. There were, okay, it's going to take about 6 to 8 weeks. And in that, you knew you would get an answer. For our Indian courts, apart from some matters which are heard at urgency at the Supreme Court level, for the bulk of us, you don't really get any sense of the predictability. And I'm not saying you can know that with certainty, but can you aspire to predictability? And then, of course, I don't know how to measure these. So I know how to measure time to disposal, time to first hearing, maybe time to, time between hearings, so that I get some kind of certainty. We define it as percentage of substantive hearings. That I want to know in how many of my hearings did the case make progress, and in how many of the case was the case kind of stagnant, which is either it was an adjournment or parties said they weren't prepared, or there was some administrative thing saying you forgot to file something. Now file. Why can't all this be done in advance with some certainty, so that on the day of the hearing, there will be progress.
Right.
And then people really want fairness. I don't know how to measure fairness. People really want independence. I don't know how to measure independence. So I have 3 or 4 measurable characteristics that are more on the operational side. And then, of course, fairness and independence, which is something everybody aspires to.
Good. Makes sense. So if we now double click on some of the statistics, I'll just take these from one of the papers that you guys published. You look at stuff like time to disposal, average number of hearings, percentage of substantive hearings, time to first substantive hearing, variability in time where you actually take an interquartile range. And like if the range is smaller, it's more predictable. And ideally an interquartile range of 0 is the dream, right? Where it's absolutely on
it's like clockwork. Yeah.
Clockwork, right. So just curious, out of this, some of this, the first 2 seem fairly simple, straightforward. You just look at dates and you can compute these metrics, right? About substantive hearings, how did you guys actually set this up, right? You need to probably read through hundreds of dates, whatever was said, because more often than not in Indian courts, it will be, we said XYZ on the last date, we are going to deliberate on ABC today. Please bring these documents. Oh, you don't have these documents? Court adjourned. Come on the next day, right? So how did you guys do this? This must have been a crazy effort, or did you have some tools to make life simpler?
Yeah. So this work starts. So Bhargavi Zaveri and Pavitra Manivanan are 2 of my teammates, and they've published this in the past. Their work is the foundation for some of this on what do litigants want and the definition of substantive, right? So they started with high court hearings, where they painstakingly by hand read all the hearings, came up with a definition, shared it with legal scholars, debated back and forth. Lawyers can't agree on a single thing ever, but they did come to some understanding, and that created a manual. And then across 22 and 23, and perhaps earlier, we used to use interns to read the order, classify it. Today, we're at the level where we can now ask an LLM to do it with some accuracy loss. Okay. Maybe we get 90% is what you get. It is doable, which means can be done as a repeat activity. You will get some errors. Sometimes code data is really bad. Sometimes it's not. Every court has its own language. So you have to count for all of those. So there is some level of human oversight that is still required today. But today there are tools which help you do this. Though I must say in at least 22, 23 and part of 24, it was done painstakingly by hand. They must have read at least 1,000 cases and all their associated auditors. And now we can do this at scale.
Okay. One question I definitely was wanting to ask you, was curious, is this is legal law reform, and what you're actually doing this is quantifying it using actuarial thinking, where you actually, like a loan has time to default and a loan has a life, you take a case and think of it along similar lines. Yep, how did you come to such a form of thinking? Like, what was journey?
So I think, so one of this is just XKDR Forum, right? Because it's a multidisciplinary organization. Ajay and Susan have been doing work in quantified, in quantitative stuff, economics, finance, all of these, right? So the instinct towards how can we use statistics? So one of the fundamental things, while we present medians and averages to the rest of the world, internally within XKDR, we don't think time to disposal should be a point statistic. We look at survival curves. So, taking inspiration from the medical field or time to loan default or any of these ideas, right? So you understand that there is a probabilistic answer, because obviously if you only take the cases that have been disposed, you're left with a lot of pending cases whose time to disposal is at minimum what the average of the disposal cases is. So it's always going to take longer. So any average that you take is going to miss out the censored out pending cases. So the strong statistical backing is part of the DNA at XKDR Forum, and it helps that there are economists and lawyers and people like me who come from a little bit of different backgrounds, but have some understanding of operations and, bottleneck analysis. And, when you divide something into stages, you want to do a funnel analysis and all of this. So we've been really trying to develop this understanding and also go back and forth with lawyers to confirm, look, are we doing the right thing? Does it make sense? Is this how cases actually move through court? A simple example was, when we tried doing this math, and we looked at the number of hearings in Bombay High Court. And we spoke to some lawyers. They said, but, cases in Bombay High Court don't actually go through the main case. They go through a lot of interim applications. So we said, good. So now we will also study interim applications. We will stitch the case together. We will stitch the full history of the case. And then we will look at it. And this comes from the fact, look, a lot of good legal research happens on judgments. And this is great. And it's extremely useful. There are lots of organizations which do precedent analysis. These are tools which are secondary to lawyers. Lawyers, I don't know if you've... okay, there are two good legal databases that almost every lawyer seems to use, Manupatra and SEC Online. They look at judgments. Now, this is great, but we don't like it because not all cases reach judgment. Not all judgments are reported. So if you want to know what happens in a normal case or then you got to look at the life cycle, and you want to know how many have dropped off before they even reached the end, end resolution. So some of this simply comes from bringing that very clear idea. And if you read, there's a paper called the Indian Courts and Tribunals Service, which Ajay and a bunch of co-authors, it's the first video that we've done on the YouTube blog, on the YouTube channel that we have, where we talk of separating the administrative and the judicial.
Right.
And the question of understanding that actually the law is two different processes. There is legal thinking, and then there is boring process management that every professional services firm, you encounter this. You encounter this in a lot of services businesses. And we must try and be, as clinical and say, look, the legal system is as much a services business. And we must apply all the ideas of, how we improve supply chains and process management and, incentives at different levels because, there are different people entrusted with different things. There are bottlenecks that would come at different processes. So bringing that operational lens to the legal system came through that. The fact that there are different people looking at the problem through different lenses, so it really helps having that multidisciplinary back and forth.
Got it. And I think Ajay had a very interesting point there, right? You can use TCS's model, like where they take care of all the operations of how any passport center will run. And ultimately, there's a Babu who decides if someone who's applying for a passport gets a passport or gets a renewal. But front to back, everything else is taken care of by a professionalized agency.
And judges are the most valuable people in our legal system. They are heavily,
Right.
It's very hard to get a great judge. You should unburden them. Ajay uses the example of a heart surgeon. Before a heart surgeon operates on the heart, there are like 10 different people who prep the person.
Yep.
Ensure the heart surgeon is not checking blood, right? They know they have the results ready. They're going to come and execute. So you want that level of administrative strength to back up these processes. And today, those don't exist. District court judges have to do everything. High court judges will complain that, they've been given responsibilities of procurement and managing, how the court runs. And maybe you need them to be in charge, but do they need to do the work? Can we not get...
really.
And these are not radical ideas because they've tried this. They tried getting court managers like from MBA schools. They got court managers and they tried to improve the process. So some of these have been tried. But I think we just need to keep trying harder and we need to get better and we need better data. Sorry, I missed one of the questions. Who is responsible for collecting this data and publishing the data that you
Right.
asked for, right? I would say that today the NIC, which runs the e-court system, has a great volume of data. They don't make it public. They should. So the first thing, we need standard data standards for defining these things. So having a case with a very clear data packet, again, has been discussed in prior e-court committees. The request that they must release data APIs that researchers can consume and do analysis. Great idea. People will then recommend. And then there's a nice feedback loop of people looking at the data, analyzing it, sending it back to the admin. Did you know? Were you aware? So one of the arguments we make is that today you look at the legal system in days, but what you really want to look for is judicial minutes. And Tariq Pe Justice, the book, makes the same argument that what you want to look at is if I sit with a stopwatch and track a case across its life cycle of maybe 3 years or 5 years, and I just start and stop the stopwatch when the case is in the hearing in court, how long does it take? I have a radical theory that at least for check bouncing cases, which we've gone really deep into, it's probably less than an hour and a half. That's stretched across 3 years or 2 years. That's really unfair. Unless we get this quality of data, you will not be able to put this kind of analysis out. Who should put it? There is standard data collection that is happening already. Every high court should choose what kind of variables they put out. The reason I say this is why we want standardization. High courts are sovereign in some ways. The constitution says that high courts are independent from an administrative function. So we can set some broad guidelines, but they should set out data releases the way they want. Maybe some of them can do deep statistics. Maybe some of them do basic stuff. And more than just publishing the stats, which is kind of great for us as researchers, what you really want is for them to use that as feedback and understand what's going well, what's going on, where's the hiccup? Do I need more police people? Do I need more process servers? Do I need more stenos? How do you make these decisions without good data?
And I think the incentive structure is also kind of weird here because with high courts, right, you can't have someone who has gone up the ranks in the high court becoming the chief justice of the same high court. This is very bureaucratic in nature. You go to a new high court, you first get your bearings, and by the time you're getting somewhat comfortable, it's time for you to go. So it's very weird incentives. And you mentioned check bouncing cases. I think there was this interesting video I came across, which I think Shubha Roy has mentioned, right? The rate of interest and check bouncing. So with check bouncing, the rate of interest set by the courts is so high that there's every incentive for you to delay it as much as possible, and yeah,
Yeah, yeah.
kick the can down the
This
road.
is the
Yeah,
thing, right? So I understand the instinct for the CJI not coming from the same high court. There is this instinct that you want rotation. It's the same reason IAS officers don't belong to the same state. I think it's the same reason.
yep,
But
yep,
I would argue that, look, yes, sure, but that's one person, that's one judge. But at the district court level, so can we do this? Can we do transfers? Can we do whatever is happening? But can we at least say that if I know in advance that a person is going to be transferred X months from now, I will stop taking in new cases, or I will take in new cases with some kind of overlap. Can there be a smarter handover? Why is it that the case almost ends and then the judge gets transferred and a new person comes and maybe they have to listen to everything, maybe they've read the notes, but
yep.
can there be some standardization? So I feel like some of this has just not been thought of deeply enough. And yes, interest rates are a problem. Yes, costs are a problem. Like, why can't you impose costs on other parties? In check bouncing is criminal. So, I mean, at least in all the check bouncing cases I've looked at, they don't even award costs. They just say, okay, at least you paid back the money, now go home. Like, it's fine. Thanks, I guess. So, some of this is law dependent. It's just such a mess. But yeah, the one thing I would argue is, can we urge people to take this process problem a little bit more seriously? And, we need all the legal scholars debating how laws are written, how judges should behave, how justices should. These are big, important questions. But can we also devote some time to the mundane, the boring
Right.
stuff, the
Boring
stuff on
stuff.
scheduling, the stuff on. So today, people use post to deliver summons. Okay. Can we try other methods? Can we, maybe for criminal matters, it's too difficult. You can't trust
Right.
online. For civil matters, can we try? Can we try improving ops? Because this is non-controversial. You said that data needs to be depoliticized. I would argue that there's, apart from some very sensitive matters like POXO and, sexual abuse and some of those difficult things, most court data is fairly harmless.
Yes.
And
Agreed.
it is already out in the public domain, but what is not out is that it's not easy to consume it easily. So you have individual cases are like, that's one of the greatest things that the NIC and the E-Courts Committee and the overall Supreme Court passed down all the way. Any case in court, you put your details. Now you will get your list of hearings. You will get all the orders. Maybe it takes 10 days to get uploaded on the website, 15, 1 month, whatever. It happens, which is great. This was not there a few years ago. I've been speaking to other people in this field and they're very, so, things are improving, but not fast enough, I guess.
Yeah, and just to drive the intuition and the motivation for getting the administrative wing right, if a court case at the NCLT had its first hearing as substantive versus non-substantive, the average disposal time varies from 238 days to 747 days. So this is not even same ballpark, right? The entire trajectory of a case changes depending upon how the first hearing goes. So a penultimate question before we wrap up. It's like this top question that I need to ask you because of the times we live in. Machine learning, can this make our courts more efficient? What do you think?
100%. Okay. But when you apply it to the right space, every time you hear about AI, you see it being applied to judges. No, judgments have to be written by judges. Okay.
Yeah.
These are things that I'm uncompromising on. Now, where can you use machine learning? When I file a case, can I get better scrutiny done? Can I do machine-aided scrutiny? You have great vision models now. So whether you use OCR. So earlier, the problem was you had to use OCR, right? In the last 3 years, you have vision learning. So even if something's written down by handwriting, some of these models are good enough. So can you make the life of the court staff easier by doing this? Can you do scheduling algorithms use machine learning? Though I would argue you start with standard bin packing algorithms, but at some point of time move to machine learning if that's useful. Can we do some of this classification of whether the hearing was successful or not successful? Like instead of allowing court staff to determine whether the hearing was an adjournment or not, can we give it to an independent group of people to tag it and get some classifications out on what were the reasons for adjournments? In how many of them was it because the petitioner didn't show up? How many of them were because some payment was not filed? Can we get deeper? So I think with all technology, I would urge its use for internal efficiency. We shouldn't get swayed by the glamour of judges writing judgments through AI. So a lot of judges today now use really good voice to text software, which is again machine learning, right?
Right.
So all of this is great, and we must use all of it. But as long as we ensure accountabilities with the right people. So if a judge wants to use AI to draft out a judgment, sure. But as long as you remember that at the end, it's the judge. So what your
Right.
backend, whether you use a really bright intern, whether you use machine learning, LLMs, whatever it is, that's your prerogative. But accountability must lie with the judge. And as long as we hold that sacrosanct, I think all these tools, all technology is good if it's used, as long as you ensure accountability does not change. You shouldn't be allowed to blame the AI. That's not an acceptable use of. So if you don't know what's happening, don't use it. But as long as you are willing to use it with those safeguards in mind, I think machine learning and AI is fine.
Should not be black boxy in nature. That's about it. Where you don't know how the boxes are work.
Yeah. And whatever it is, as long as it's your accountability, right? So when I tell you our classification algorithm has 90% accuracy, it's something that you should remember and say, look, if I'm going to make extremely high levels of a decision making based on that classification, maybe I expect that bar to be 95 or 99. And then I want to keep pushing, I want new sets of data. I want human validation. So all of those things can be done. And I believe financial firms do this.
Yeah.
They use machine learning, but they don't allow it to go crazy because there's some real value that you could lose. We've seen disasters in the past with like flash trading and stuff like that. So every industry recognizes this. So I don't think the judicial system is any different. They just need to remember that the people in charge are the people in charge. The tools are the tools.
My final question, and I'm super chuffed to know this, learn about this. What are you working on now? I think this is an area where you have spent 3 years. Are you doing more work in legal reforms? If so, what aspects are you focusing on currently? What is the kind of data you're looking at? Super interested to know.
Yeah. So at least for the last 1 or 2 years, we've been doing the same two things, which I look at it as, okay, look, there's some demand side change that needs to happen, which is from the people, from the customers, from the consumers of the legal system. We must demand better. Okay. We must demand better of lawyers, of judges, of the broader system. To this end, we are kind of setting up the foundation of what we think is legal analytics. So the 4 or 5 metrics we spoke about, we think we can do this for any court now.
Okay.
And we want to see how that idea can be pushed further. Can we get people to make smarter decisions on litigation using this data? How can we get lawyers and law firms and corporate firms and general counsels, how can we get them to incorporate statistics into their decision making? If it's a money recovery case and the cost of recovery is so much and your NPV is so long, it's not worth it. Maybe you just litigate 10% of cases and get a high reward, push it as an example, but don't blindly litigate, right? Can we use statistics to get litigants to demand better? And then on the supply side, we are part of that collaborative called Pukar. It's a collective which is working with the Kerala High Court. So we're helping with, operational data from the court. How can that be understood? What should you be tracking? How should the court use this data to make better decisions on operational management? So we're part of that collective. It's a process of iterative improvement. The courts in Kollam has been running for about 6 to 8 months now, and early signs of that things are going well. But again, it's too early perhaps. How do you push that kind of operational thinking onto the legal system and keep doing conversations on finding, I think just the number of people working on empirical analysis of the legal system in India, it's not large enough. So we need more students, more researchers, as many people staring at data, applying all the good knowledge of operations and statistics and everything else in the rest of the world has figured out. We need that lens applied to the legal system. And we need to sit with lawyers because they understand the space. But if you can find a bunch of lawyers who will listen to a bunch of statistics, I think there's a nice match there. And yeah.
It's good that you guys are actually piloting your hypothesis in a court. And although it's small scale, you're not letting perfection like stop progress, right? You're going to tinker around with the model, learn on the fly, make mistakes as expected, but eventually hope we will get it right someday. So that's heartening to know.
Yeah, and it is a journey of persuasion because we are outsiders, right? We are knowledge partners to the court. So it is the court, you need to persuade the court that A, this is the right way to think about it. B, this is useful data to collect because any data has a cost to collection. Then you need to process it. Then you need to interpret it. And then they need to take action. So it is that journey of persuasion, which is also teaching us a lot about how are the people who are in charge of the system, how do they think of the problem? What are their kind of questions, and I think there is this thing that it is only when you're kind of inside a system a little bit, are you sympathetic to the needs and the urgencies and the issues? Because from the outside, it's easy. It's a bit, and of course, as outsiders, we have no other choice but to use it. But I think when you sit with people and understand what their issues are, or even just spend some time in district courts, I think it gives you a nice, more rounded sense of what's happening.
Thank you, Siddharth, for your time today. This was indeed a great masterclass. It was very illuminating to learn about all the work you're doing in marrying legal processes with statistics and making, I think, the legal arena less arcane, because for an engineer before B school, for me, judgments were all about dense legalese that you could not make head or tail out of. B school changed a bit of it, but now that you guys are actually making it quantitative in some sense, it should become more analytical for a lot of us. Thank you so much.
Yeah, and thank you so much for inviting me. And I love the fact that you're doing this podcast series. I mean, you spoke about people. I mean, I think both of us have kind of walked off the standard path in some ways. I know you're still maintaining your day job, but it's awesome. So I'm assuming you do this on weekends and you do your day job, and it's kind of awesome that you managed both.
Yeah. Yes. Thank you so much. Thank you.
All right.
Cheers.
Take care.
Good night.
Bye.
Bye-bye.